Welcome to the deep dive. Today we are strapping in to examine the absolute bedrock of Western legal thought. We often talk about how modern law is structured, from contract negotiations to constitutional rights. But to truly understand the architecture, we have to travel back,
Yeah,
way back, to the sources.
that's right.
We've got a really rich stack of research here detailing Roman and Greek jurisprudence, their civil structures, and, well, the raw legal philosophies that defined what it meant to be governed back then.
Exactly. Our mission today is pretty foundational. We're trying to extract the core principles that underpin these ancient legal systems, especially
Ah,
in the big centers, right? Rome and Athens.
right.
And we need to see how fundamentally things like status, personal philosophy, and just deep, deep history shaped what they even considered justice.
And it wasn't static, was it? Not just stone tablets.
No, absolutely not. That's crucial. This was a constantly developing intellectual framework. I mean, it spanned 1,000 years, constantly evolving.
And what's really key for you, the listener, to keep in mind is how we approach law's development itself. One source we always seem to come back to is the work of the legal scholar Maine. He had this idea.
Oh, Maine's insight is foundational here. He observed that legal ideas and institutions, they have a real course of development. It's almost biological, like the genera and species of living creatures.
A natural history of law, he called it.
He did. And the core idea is that law evolves organically rather than being suddenly created whole. So if we accept that, we have to track that evolution today. And we need to start at the most primitive core.
Which isn't the state.
No, not the state, not initially. It's the family.
Okay, let's dig into that.
So when we approach the genesis of Roman law, especially in its earliest form, yeah, we can't start with the Senate or the assemblies, the formal stuff. We have to start with the household
The house itself.
because the evidence really suggests that the core concept of private law, it existed before the city-state, before the polis.
So law predates formal government.
In a sense, yes. This early private law wasn't really designed by a legislator. It was almost imposed upon the legislator. It springs spontaneously from, well, ancient religious beliefs and these deeply ingrained customs.
It's fascinating how tightly religion and private life were woven together back then. So you're saying the patriarchal unit, the family, was probably older than the state or even the tribe.
Very likely. And it left these profound, indelible traces on all the jurisprudence that came later. This is the absolute foundation of the father's power, the patria potestas.
Ah, the Patriot Potestas. That sounds significant.
Oh, it was. Kinship, in this ancient family structure, it wasn't just blood. It was defined by the community of the same domestic gods, and crucially, the right to offer sacrifices to the sacred fire.
Okay.
And this right, this religious connection, was transmitted only from male to male,
Only male to male.
which led to this concept that's frankly hard for us to grasp today. These ancient generations genuinely believed the female transmitted neither being nor worship.
Wow. So legally and religiously, the son belonged solely to his father's family and his father's gods. All identity flowed through the male line.
Exactly. And this religious definition gave the father, the paterfamilias, immense power. And when I say immense, I mean almost absolute.
How absolute are we talking?
We're talking about ancient law found in both Greece and Rome that allowed a father to sell his adult son or even kill him.
Kill his adult son.
Yes. Now, the city, the state, eventually accepted this concept, this pre-existing power, but it only modified its rigors very slowly, by gradual degrees over centuries. For a long time, the domestic sphere was basically a sovereign entity. Its power existed long before the city truly centralized its own public authority.
That level of authority over another adult life is just staggering. It really shows how limited the state's initial reach was into private life. Okay, let's shift to the first big Roman codification we know about, the 12 Tables.
Right.
We often imagine these early laws as, I don't know, lofty principles.
Hmm.
But what do the tablets actually tell us about the raw nature of justice back then?
They tell us a lot. Primarily, they show us a society that one source describes as being in a state of extreme poverty.
Okay.
And the legal system reflected that. It was rigid, very specific, and heavily concerned with setting a quantifiable price for injury. They basically invented the price list for human damage.
A price list. And that list revealed who the state actually valued.
Precisely. Give us some examples. What kind of prices are we talking?
Well, the penalties were often based on direct retaliation, an eye for an eye, literally,
Right, the lex talionis.
or these fixed monetary sums. For instance, the 12 Tables decreed physical retaliation for destroying someone's limb. maiming.
Okay, straight up vengeance.
But if you only broke a bone, the penalty became numerical.
Yeah.
There's a fine of 300 asses if the victim was a free man.
300 asses, what does that mean in real terms? That as was a small copper coin. Like.
Yeah, tiny. 300 might have been maybe a few months' income for a laborer back then, so significant, but a fixed sum, no nuance.
And I bet there was an immediate distinction based on rank, even then.
Oh, absolutely. Baked right in. If the victim of that broken bone was a slave, the fine instantly dropped to 150 asses.
Half, just like that.
Exactly. And for all other sort of lesser injuries or outrages, maybe a slap, an insult, the fine was a mere 25 asses.
25. Practically nothing.
Yeah. This rigidity, this reliance on fixed sums, it was maybe practical for a very basic society trying to stop blood feuds.
Sure, keeps things simple.
But it obviously became insufficient pretty quickly as society got more complex and, injuries got more nuanced than just a broken bone or a missing limb.
And this leads us perfectly into the next big step, the huge transformation of Roman law through the jurists and the magistrates. This rigid system, it couldn't last.
Right, it gets modernized.
Significantly modernized, mainly by the praetor. He was like an inventive chief magistrate, and he used something called the hennesis honorarium.
The law, based on his office, his honor?
Essentially, yeah. Law derived from the magistrate's discretionary power. And the praetor's big innovation was allowing the plaintiff, the injured party, to move away from those rigid, 25 asses fines.
Oh, okay.
They could make their own assessment of the outrage, the injury. Now, this was subject to a judge's, the iadex's discretion, but it meant the penalty could finally reflect the actual severity of the offense, especially for aggravated cases like a serious wounding or an outrage against a magistrate or done in public.
So the brilliance wasn't just in the laws they wrote down initially, but in the ongoing commentary and application of that law.
Yeah.
Which we know about mainly through the digest, right?
Undeniably. The single most important source for our knowledge of what we call classical Roman law is the Digest of Justinian.
And that's much later.
Much later. This isn't a book of early laws like the 12 Tables. It's a massive compilation, 50 books filled with selections from the huge commentaries written by the most influential classical jurists over centuries.
So Justinian's team in the 6th century AD basically curated centuries of legal thinking.
Exactly. They compiled it, preserving what was still considered valid Roman legal thought. It's an incredible repository.
So going back to those praetors, using their judicial authority, their inorentis honorarium, they essentially built an entire jurisprudence of dealing with personal affronts, all starting from those meager 25 asses rules in the 12 Tables.
They really did. They constructed this comprehensive law of redress for personal affront called the Actio Injuriarum, and its scope widened far beyond simple physical damage.
Okay, so what else did it cover?
This is where Rome basically invents the concepts that become modern libel and slander. The Actio Injuriarum eventually included any willful damage to a man's dignity or his standing in the community.
Even if the harm was purely reputational or psychological.
Yes. They moved the law from primitive retaliation, an eye for an eye, or 300 asses, to sophisticated concepts of legal dignity and protecting one's reputation. It's a huge leap.
Okay, so moving past that patriarchal core and the early kind of rough codes, Rome's global reputation really rests on its legal genius in structuring commerce, the economy. They are, for instance, credited with the invention of wills. And our sources say they viewed the family almost like a legal corporation, something that continues across generations.
Yeah, the inheritance laws are fascinating in that respect. And the development of contracts, well, that shows a spectacular leap in legal sophistication, too.
How so?
Most legal systems, they start with a pretty conservative principle that mere agreement, just a handshake and a promise, that doesn't automatically generate a legally actionable outcome. You needed something more concrete, more formal.
Right, you needed explicit formalities. What kind did the Romans have?
Well, they certainly had those. You had verbal contracts, like the famous stipulatio, that required specific ritual words to be spoken aloud in a question and answer format.
Okay, a verbal ritual.
And you had real contracts. These required the actual physical handing over of a tangible object, a res corporalis, like lending something or making a deposit. If you didn't perform those explicit steps, the agreement just wasn't legally binding under the old civil law.
But then they developed the concept that is truly foundational for basically all modern commerce, the consensual contract.
Yes, the consensual contracts. These were the groundbreaking exceptions to that general rule. Things like sale, hire, partnership, mandate. these really important high-volume types of economic
And
agreements.
for those,
For those, consent alone was enough. Consent sufficed to generate a legal action. No special words, no mandatory handover needed, just the meeting of minds.
that's huge. And what's fascinating is you mentioned these were designated as juris gentium, the law of nations. Why that specific label?
Ah, that's really telling. Calling them the law of nations signals their purpose and origin. It tells us about necessity and sheer pragmatism.
How so?
These agreements were recognized as suitable for regulating transactions involving non-Romans, foreigners, people across the vast empire. They needed rules that worked everywhere, for everyone, without requiring participants to know or perform archaic Roman civil law rituals.
So practical rules for a globalized economy.
Exactly. They prioritized the efficiency of the transaction, the consent over the strict old formalities. This was the legal engine room of their sprawling commercial empire. It had to be simple and universal.
It's a classic example of law being forced to adapt to economic reality. Okay, shifting gears slightly to property. We see a similar kind of clash maybe between history and practical utility in how assets were defined, right?
Right.
Roman law had these classifications, res mancipi versus res nec mancipi.
Right. And this distinction, it often seems really arbitrary to us now, but it's a pure example of Maine's natural history of law in action. The classification was fundamentally historical. It wasn't based on philosophy or economic value.
Okay, so what determined if something was res mancipi?
Basically, property that was earliest known and most critical to the early agricultural community. Things like land in Italy, slaves, beasts of burden like oxen and horses. These received the designation of superior property, res mancipi.
So superior status just meant older status. It was there first.
Precisely. Our sources make this incredibly clear with a fantastic example. Get this. The most costly jewels, diamonds, gold artifacts, items of immense economic value, even then, they were never ranked as res mancipi.
Never? Why not?
Simply because they were unknown or unimportant to the early Romans when that catalog of superior property was essentially closed. Tradition, or maybe just ancient inertia, legally outweighed immediate economic value.
That's incredible. So the legal status of your pile of gold might be lower than the status of your old family ox, just because the ox, or the idea of the ox, was legally recognized first.
Exactly. It's a perfect illustration of law reflecting its own history, not just current reality.
And this legal complexity, this love of categories, it extends to how rights over property were divided too, leading to these incredibly precise rules we find in the digest about things like usufruct.
Ah, usufruct.
Yeah.
Yes, a concept we still grapple with today in different forms. It's the right to use and possess property belonging to someone else, but without actually owning it. You get the fruits, the use, but not the thing itself.
Okay, and how complex did the Romans make that?
Meticulously complex. Unbelievably so sometimes. For instance, the digest detailed situations like, okay, imagine a slave is subject to a usufruct. So one person has the right to use his labor, but another person actually owns the slave.
Right, divided rights.
Now, what happens if that slave is stolen?
Uh-oh. Who sues?
Both. Both the usufructuary and the owner had an action for theft, but, and this is the Roman genius part, they sued for different things, reflecting their different interests.
Wait, seriously. So even if the slave is just gone, the owner and the user have to file separate legal actions. That sounds like a nightmare.
It does from a modern perspective, maybe, but it shows their incredible intellectual rigor. The usufructuary sued for the value of the fruit. They lost their immediate interest in the slave's use and labor. The owner, meanwhile, sued for their interest in the actual property itself not being stolen, the capital value.
So they divided up the penalty based on the type of interest lost.
Exactly. This division of a single penal action shows this incredibly advanced, almost abstract legal mindset. They could conceptually slice up rights very finely.
And that obsession with detail, it spills over into, like, neighbor disputes, too, what the Romans called servitudes.
Absolutely. Servitudes were these specific rights attached to the surface of the ground, often retained by simple possession over time. And they cover incredibly mundane yet crucial details of how neighboring properties interact.
Mundane, like what?
Like the right to have a supporting beam let into your neighbor's wall. Or a classic one, the right to discharge rainwater from your eaves onto your neighbor's adjacent land.
The level of detail required for a legal system to formally regulate where rainwater lands, that's just mind-boggling.
And the foundational rule they developed for servitudes shows this deep logic and a real commitment to balancing rights, protecting the owner of the property bearing the servitude. The rule was basically this. A servitude could be made less onerous for the neighbor, but never more so.
Okay, explain that with the rainwater example.
Right. So, if you had the right to let eaves drip water from your roof fall onto your neighbor's land, you could choose to start discharging it from a higher level on your roof. Why? Because water falling from a greater height actually lands less forcibly. It disperses more.
So you're making it less aggressive, less burdensome.
Exactly. But you could not modify it to discharge from a lower level, because that would create a more concentrated, steady flow of rainwater, making the servitude more onerous, more burdensome for the servient owner next door.
Wow.
This insistence on balance and fairness within private law, right down to the physics of falling water, it's pure Roman legal genius at work.
That incredible attention to detail in private law, like with rainwater. It seems to contrast really sharply with what we see when Rome's legal system turned its focus on people, onto status, and especially onto criminal justice, particularly in the later imperial age.
Yes, that's a very stark contrast. When we transition there, we encounter the formal, explicit institutionalization of inequality. Status wasn't just a social fact, it became a defining legal reality.
And the most obvious example is slavery.
Absolutely. We have that striking definition from the jurist Florentinus, defining slavery as, quote, a practice of the law of nations by which one person is subjected to the dominion of another, contrary to nature.
That phrase, contrary to nature, that's a huge philosophical admission, isn't it? Coming from within a society that absolutely depended on slave labor.
It really is. It shows the inherent philosophical tension, the discomfort within the system itself. Now, the law itself was quite practical about the sources of slavery. People became slaves primarily by just gentium the law of nations again, meaning captured in war or simply being born to a female slave, or sometimes through the civil law, like the rather strange case noted where a person over 20 years old might allow himself to be sold collusively just to share in the sale price.
Wow, okay. A desperate measure. Yet later on, we do see efforts, don't we, to mitigate the worst brutality of the system. It wasn't completely unchecked power forever.
That's right. Although they never came close to abolishing the institution itself, both philosophy, particularly Stoicism, and later, Christian influence did help soften the rigors of Roman law regarding slaves.
How so? What changed?
Well, masters were eventually forbidden from selling slaves into fates like being gladiators, or forced into prostitution without a specific, justifiable cause shown to a magistrate. They also couldn't punish slaves excessively or kill them outright. Unless the death resulted from what was deemed reasonable punishment, which, of course, leaves a lot of gray area.
A huge gray area. But what practical recourse did a maltreated slave actually have? Could they do anything?
This is actually quite revolutionary for the time. A slave could seek asylum. They could flee to a public space, an emperor's statue, a temple, later a church.
And what happened then?
A magistrate would investigate the complaint. If they found it valid that the slave was being genuinely maltreated beyond the bounds of law, they could order the slave to be sold, compulsorily sold, to a different, hopefully less cruel, master.
So not freedom, but protection from extreme abuse.
Exactly. These laws were probably driven as much by the imperial government's desire for social order and stability as by pure humanitarianism. But they did create a tangible legal limit on the master's power. It wasn't absolute anymore.
But these status distinctions, they weren't just limited to the stark line between free and slave, were they? Roman law formally differentiated between social classes, even among free citizens, when it came to criminal punishment, creating what sounds like a legalized two-tier justice system.
This is perhaps one of the most chilling aspects of imperial justice for modern eyes. The formal legal distinction between the omnestiores, basically, those of superior status, the more honorable ones, the elite, and the humiliors, those of low rank, the common people, the lower orders.
And this wasn't just social prejudice, it was written into law.
Explicitly. Our sources, the legal texts themselves, confirm that imperial rescripts direct orders from the emperor laid down that honestiores should not be subjected to physical punishments like beating. That was considered degrading for their status.
So who got beaten?
Only those of the lower orders. The tenure homines, the thin men, were beaten with rods. The law openly, formally codified unequal treatment based purely on social standing.
Can you give us a concrete example of how this differential sentencing worked in practice, just to show the sheer scale of the injustice?
Yeah, there's a very clear ruling cited from the Emperor Antoninus Pius. It concerned a man who killed his wife after catching her in adultery. A serious crime, certainly.
Okay, what was the sentence?
It depended entirely on his social rank. Not on the circumstances of the crime, just his status. If the man was an honestier, part of the elite, he was to be relegated to an island.
Relegation, so exile.
Yes, exile. A serious punishment, involves loss of rights, banishment, but it preserved his life, generally his property, and a semblance of his former status. He wasn't subjected to hard labor or execution.
Okay. And if he was not from the elite, if he was humulus loci, of low rank?
Then he was condemned to hard labor for life, probably in the mines or quarries. A brutal, often short existence.
So the exact same crime results in wildly different life-altering punishments. Exile versus a likely death sentence through labor, based solely on whether you were born into the upper class or not.
Precisely. It's inequality enshrined in law.
And even the process for appealing to the emperor, the ultimate authority, that was complex too, and it changed over time, didn't it? Reflecting how power shifted.
Absolutely. We see two distinct systems of appeal described, which really show the evolution of imperial power. There was provocatio. This was the older, originally republican practice.
What did that involve?
If a citizen facing a capital charge invoked provocatio, the magistrate, the judge, either had to stop the trial altogether or could only conduct a preliminary investigation. The ultimate decision was then passed up to the People's Assembly originally, and later, effectively, to the emperor.
So it was a powerful check before conviction. A way to halt the process if you felt it was fundamentally unjust.
Correct. It was a strong shield against arbitrary action by a magistrate. Now, contrast that with appellatio. This was the standard procedure of the later empire.
And how did that work?
Appellatio was universally allowed. Any sentence could theoretically be appealed. But it happened only after a sentence had already been pronounced by the lower court or governor.
Ah, so it was a request for review, or maybe mercy, after the damage was already done, after you'd potentially already been convicted, maybe even punished.
Exactly. It shifted the power dynamic. Provocatio could stop the process. Appellatio was about trying to overturn a decision already made.
It sounds like the early empire, when provocatio was maybe still stronger, offered some serious protections to citizens, at least on paper. But we also have those stories, don't we, of those protections just being completely ignored by arrogant or cruel governors.
Indeed. While citizens technically had the aurigus provocatianus and the annus regarum, the right to appeal and the right to be spared rods and certain humiliating punishments, that protection wasn't absolute in practice.
The shield could fail.
It absolutely could. We have historical examples like the notorious case of Governor Galba. He reportedly crucified a Roman citizen who had committed poisoning. The man apparently kept crying out, "Civis Romanus sum, I am a Roman citizen," appealing to his rights.
And Galba.
Galba reportedly ignored him completely and had him crucified anyway, perhaps even on a specially whitened cross to make an example. So the legal shield was ultimately only as strong as the governor's respect for the law, or perhaps more accurately, his fear of being called to account by the emperor. Power could override law.
Okay, let's shift our focus now. We spent a lot of time on Roman pragmatism, its detailed rules, and that deep hierarchy of status. Let's turn to Athens. Athenian justice, particularly around something as fundamental as homicide, seems rooted in something different, doesn't it? Maybe more ancient.
Yes, it's a fascinating contrast. While Rome eventually codified inequality based on social rank, Athens, despite its democratic ideals, based its most fundamental justice, especially for homicide, not on rank, but on the even older criteria of kinship and piety.
Kinship, so family ties determine justice.
In homicide cases, absolutely. The law, famously linked back to Draco's legislation centuries earlier, was fundamentally based on the idea of the solidarity of the victim's kin group. Avenging a slain kinsman wasn't just permitted, it was considered a matter of piety, a religious duty, as well as a legal right.
How did that work procedurally?
The prosecution process itself, the dikiphono, the lawsuit for homicide, absolutely required the prosecutor to prove they were properly related to the victim. They had to swear a specific, solemn oath about their kinship, the diamosia. Without that kin connection, you couldn't bring the case.
So it really does sound less like a modern criminal trial initiated by the state and more like a kind of sanctioned, regulated process for private vengeance just routed through the state's courts.
That's a very good way to put it. But what happened when this deeply ingrained cultural mandate for vengeance collided with the equally strong need for family loyalty? Say, if the killer was also kin.
Homicide within the family. That must have created huge conflicts.
Severe societal and personal conflicts. You have the religious duty to avenge your slain kin, but that clashes directly with the need to maintain philia, the bonds of affection and solidarity within your own kin group.
So what usually won out? Vengeance or family unity?
The evidence we have, scattered as it is, overwhelmingly suggests that family solidarity generally won out. Kin often chose not to prosecute a killer who was one of their own, prioritizing the stability and survival of the immediate family unit over the external legal demand for vengeance.
That makes a certain pragmatic sense, I suppose. But what about the opposite problem? What if the victim had no kin, no family to take up the cause?
That was the glaring systemic gap, a real blind spot in the Athenian system. Our sources describe, for example, the unfortunate hypothetical case of a freed woman, someone formerly enslaved, likely without strong family ties, in Athens who gets killed.
What happens to her?
She simply fell through the cracks, as the source puts it. Under the logic of the dikephonu, she had no one qualified by kinship to prosecute on her behalf.
So, no kin, no justice.
In the specific context of the homicide prosecution, yes. The logic was rigid. The business of avenging a killing belonged properly and religiously to the victim's kin. If the kin didn't exist or wouldn't act, the system, at least for that specific procedure, had no automatic mechanism to step in and prosecute on behalf of the community or the victim.
That is such a stark contrast to modern ideas of public prosecution, where the state is supposed to act on behalf of any victim, regardless of family ties. How did Athens handle other types of offenses then? Non-homicide cases. Was it all based on kinship?
No, and that's where we see a really interesting, quintessentially Athenian democratic innovation. This is where the reforms attributed to Solon, the great lawgiver, come in.
Solon, what does he change?
Solon is credited with fundamentally altering the constitution to permit anyone who wished, hobulamenos in Greek, to seek retribution on behalf of someone who had been wronged, at least for many types of public offenses.
Anyone who wished. That sounds incredibly open, like radical civic power.
It was. Athens famously had no single official public prosecutor like a modern district attorney. Instead, the citizens themselves were responsible for initiating and pursuing charges for public wrongs.
Any citizen could just decide to prosecute someone.
For many offenses, yes. This principle of voluntary prosecution by hogomamenos was absolutely fundamental to how Athenian democracy held its officials and powerful individuals accountable. Procedures like the dokimasia.
That was the vetting process for officials, right, before they took office.
Exactly. A hearing into a candidate's past conduct and fitness for office, and the euthanae, the audits of magistrates' accounts after they left office. Both relied heavily on hobulamenos, any citizen being willing to step forward and bring issues to light.
Okay, I can see how allowing any citizen to prosecute is democracy in action, ensuring accountability. But surely it opened the door to absolute chaos. Endless litigation, political vendettas, people making a career out of accusing others, the sycophants we read about.
Oh, it absolutely did. That was the downside. The risk of malicious prosecution, of using the courts for personal or political gain, was incredibly high. And the problem of sycophants, these vexatious litigants, is a constant complaint in Athenian literature and court speeches.
So it was messy.
Extremely messy. But the potential benefit from the Athenian perspective was that public accountability wasn't dependent on a single, potentially corruptible or lazy centralized office. It was guaranteed, in theory, by the collective vigilance and civic responsibility of the entire citizen body. It allowed the democracy to function with this really open, if often chaotic, public scrutiny. It ensured that almost no official was ever truly beyond challenge from below.
Okay, one last area to touch on. Beyond the specific rules of Rome or Athens, we have the philosophers wrestling with the ethical basis of law itself, trying to figure out not just what the law is, but what it should be, seeking what Cicero, for instance, called the honorable.
Exactly. Thinkers like Cicero, often drawing heavily on Greek philosophy, especially Stoicism, they weren't just restating Roman legal rules. They were trying to find a deeper moral foundation for law and conduct. Cicero tried to distill this concept of the honorable honestum into a kind of moral blueprint for civic life.
And what did that blueprint look like?
He argued it originated from four main parts. First, recognizing and perceiving the truth, basically, intellectual integrity. Second, safeguarding human association, which involved justice, giving each person their due and keeping faith, being trustworthy. Third, greatness and strength of spirit, essentially courage and resilience. And finally, order and due measure in everything you do and say, temperance, propriety.
That provides a kind of moral scale, doesn't it, to measure actions beyond just, whether you broke a specific Roman statute and owe 25 asses.
Precisely. It aims higher than mere legal compliance. And Cicero found a central moral precept running through this, governing human relations.
Which was?
It sounds simple, but it's profound. Not to harm another for one's own gain. Nequid bovem, don't profit by harming someone else.
Okay. Simple rule, but huge implications.
Huge implications. And this precept led directly to some really serious intellectual debates among the Stoic philosophers who followed, particularly concerning ethics in the marketplace in commerce. Where does legal compliance end and true moral duty begin?
This is where we get that famous dispute about whether a seller has to disclose defects in something they're selling.
It's the perfect illustration of this philosophical tension. The specific scenario they debated was, must a seller disclose known defects? Let's say someone is knowingly selling grain that's about to spoil, or a house with hidden structural problems, but maybe the civil law doesn't explicitly require disclosure of those particular defects.
Okay, so what do the philosophers say?
Well, there was a split. Diogenes of Babylon, a prominent Stoic, apparently thought it was unnecessary if it wasn't legally required. Basically, caveat emptor, let the buyer beware. If the law doesn't force you to disclose, you don't have to. Your only duty is to follow the law.
So for Diogenes, legal compliance is the ceiling of morality in that transaction.
Pretty much. But another major Stoic, Antipater of Tarsus, strongly disagreed. He believed that a truly good, honorable man must disclose those defects, regardless of whether the law compels him to or not.
Why?
Because failing to disclose, knowingly letting the buyer be harmed for your own profit, violates that core principle, not to harm another for one's own gain. Antipater insisted that the honorable path must always supersede the bare minimum required by the letter of the law.
And that intellectual friction, that argument over commercial disclosure, which, let's face it, we still grapple with in regulatory debates today. It shows these philosophers trying to bridge that potentially huge gap between pure legal technicality and genuine moral integrity.
Exactly. It shows that even within the most sophisticated philosophical schools of the time, the definition of what constituted truly honorable conduct, especially in the messy world of commerce, was far from settled. They recognized that their legal codes, as complex as they were, might not be enough to guarantee real justice or ethical behavior. Hashtag outro.
Wow. We have certainly taken a very deep dive today into the foundations of ancient legal genius. We've really uncovered the dense complexity of Roman legal thought, haven't we? From its almost primal, patriarchal, religious core, where a father literally had the power of life and death, all the way to its highly sophisticated and frankly troubling imperial status distinctions.
Yeah.
That sharp line between the privileged honestiers and the oppressed humiliores.
And then contrasting that with Athens, where we saw justice initially rooted so deeply in kinship and piety, almost tribally, before it evolved into that radical system of voluntary public prosecution by hobolomenos, ensuring this constant, if chaotic, political scrutiny.
What really stands out, though, is the sheer intellectual and legal architecture they built across the classical era. I mean, centuries of incredibly complex rules on everything from usufruct and property rights to protecting reputation and structuring contracts, all detailed across thousands and thousands of pages by these jurists and philosophers. The knowledge existed, right? It was preserved meticulously in compilations like Justinian's Digest.
The knowledge is absolutely there. It's written down. It survived. But the systems, the institutions required to understand and apply that knowledge, those are much more fragile.
Right. The knowledge is one thing, the machinery to use it is another.
Precisely. And if we connect this to the bigger picture, maybe looking forward from the ancient world, it raises a really important, maybe sobering question for all societies that inherit this kind of complex wisdom. What actually happens when a society loses the institutional capacity to apply, or maybe even to read and understand, that complexity?
What happens to the idea of sophisticated justice?
Exactly. What happens to nuanced justice, like the fine points of servitudes or the actio injuriorum for protecting dignity when the courts decay, when the educated magistrates disappear, when the institutional structure supporting the law crumble?
The knowledge might remain, locked away in the text, but the machinery is gone.
Yeah. It leaves the dry, highly intellectual, sophisticated legal text maybe as the most enduring yet ultimately silent legacy of a vanished civilization. And if that sophisticated legal capacity vanishes from practice, what rises to fill the void? Often, historically, it's not nuanced law that reappears first. It's often raw power, maybe custom, maybe force. It demonstrates that sophisticated justice isn't a given. It's a delicate, hard-won institutional achievement. Easily shattered, incredibly difficult to rebuild.
Something to think about, definitely. Especially the next time you look at a complex contract or just feel the basic protection of your dignity under law. Where did that really come from, and what does it take to keep it?